Ready? All right. Good afternoon and welcome. Welcome to the American Indian Heritage Month recognition ceremony for honoring American Indians here in North Carolina. I'm Curry Bird, an enrolled citizen of the Sisseton Wahpeton Oyate of the Lake Traverse Reservation in Sisseton, South Dakota, and of Lumbee tribal heritage, whose community I grew up in Robeson County. I'm the director of the North Carolina American Indian Heritage Commission. I'm assisted by Quinn Godwin, a citizen of the Lumbee tribe from Pembroke, North Carolina, who serves as my associate director. The North Carolina American Indian Heritage Commission was established in November 2021 and is advised by a board of commissioners representing the 12 tribes and organizations of North Carolina. The commission works to preserve, protect, and promote American Indian heritage in North Carolina. I'd like to start with a land acknowledgement developed by the Commission here in North Carolina. The land acknowledgement reads, "The state of North Carolina is situated on the ancestral homelands of many American Indian tribes who have lived in this place, cared for these lands, traveled the region for thousands of years. Tribes spoke different variants of Algonquin, Iroquoian, and Siouan languages. We honor them as first stewards of this place and acknowledge with sorrow and remorse the violent history of their dispossession and forced removal. We respectfully acknowledge the Coharie, Eastern Band of the Cherokee, the Halawa Saponi, the Lumbee, Meherrin, Occaneechi Band of the Saponi, and the Waccamaw Siouan, and honor the enduring presence, vibrance, and diversity of their contemporary indigenous communities." I would also like to now introduce our guest speaker, Dr. David Wilkins. Dr. David Wilkins is a citizen of the Lumbee Nation of North Carolina. He earned a PhD in political science from the University of North Carolina at Chapel Hill. He concentrates much of his work on Native politics and governance, with particular attention on the transformations that indigenous governments have both coercively and voluntarily engaged in from pre-colonial times to the present. The concepts of native sovereignty, self-determination, and diplomacy are at the heart of Wilkins' research and teaching. He has been a visiting professor at Dartmouth College, Harvard University, and Wake Forest University. Wilkins is the author or editor of over 20 books, including most recently, Indigenous Governance, Clans, Constituents, and Consent. Also of Livingstone, which I hold here, Perspectives on Continuous Knowledge of the Work of Vine Deloria Jr., co-edited with Shelley Hughes Wilkins. Before coming to the University of Richmond, Wilkins was the McKnight Presidential Professor in American Indian Studies at the University of Minnesota, where he also held appointments in law, political science, and American studies. Please welcome Dr. David Wilkins.
Good afternoon, folks. Good to see you. Good to see you. I'm really excited to be back here. This is the first time I've been in this building since 1980, I guess it was. I worked here for 2 years, in 78 and 79, and part of 80. Danny Bell, where you at, Danny? Danny and I were roommates together in several places. We kept getting evicted for various things, which I won't talk about. Just kidding. But we had a good time. But I landed a position in the Department of Archives and History, which is still here. And I spent about a year doing research on Danny's nation, the Coharie people. Did a genealogical study, tracing their origin points, trying to sort that out. I followed a methodological framework that Michelle Lawinghead did on our people, the Lumbee people. And it was really fascinating. I got a deep dive into how to do archival research and had a really wonderful run here. And then I left this position and moved over to the Department of Archaeology and learned about that and went on a couple of sites and learned how archaeologists do their trade. But while I was here, I also met Helen Shearbeck. How many of you know Helen Shearbeck? Very good. She was a dominant Lumbee figure, a real titan of our nation. She was here in Raleigh sometime in, I guess it would have been the spring or the fall of '79, attending a conference, giving a talk that was sponsored by the Department of Education. They were trying to figure out how to define who an Indian was for purposes of that federal law. And so I went over and I gave a little presentation as well. But Helen and I got to talking after it was over, and she asked me what my plans were. And I said, well, I'd like to go to graduate school, but I'm not quite sure where to go. And she said, well, Vine Deloria just started a master's program at the University of Arizona. You can go out there in 2 years, have a master's degree in federal Indian policy and law. And it sounded like just what I had been waiting for. And she said, well, I'll let him know that you're interested. Vine was the indigenous superstar. His books really set the stage on which Native Renaissance and political revival occurred using his concepts, his ideas. He wrote 30 books plus, hundreds of articles. And when she described that program, it was perfect. And she said, well, I'll let him know that you're interested in his program. And I said, sure, okay, that'd be great. As if she really knew him. I didn't know that she really knew him, but he called me up at my workplace the next week in archaeology. He said, Mr. Wilkins, I hear you want to come to Tucson. I said, who is this? This is Vine Deloria. I said, are you really Vine Deloria? He said, well, hell yes, I'm really Vine Deloria. And then he described the program, and it was, sure enough, tailor-made for my interests. And I went out and studied under him in 81, 82, got my master's degree. And he and I became, over time, good friends. And I had the pleasure of writing 2 books with him before he passed. And then my wife and I have done a couple of books about him. And the one that Carrie's show just came out a few months ago. So I really am happy to be back here. I mean, Raleigh's changed a lot, but this building really hasn't changed that much. So it's really, really just nice. And thank you again, Carrie, for the invitation. Thank you, Quinn Godwin, for being here. I've got some relatives here. They came over, and I'm really happy to be here, and I'm looking forward to sharing my thoughts with you all about this important time and this important subject, this whole citizenship status of indigenous peoples. As Carrie said, I belong to the Lumbee Nation of North Carolina. We're a quasi-recognized nation, and I say quasi because Congress passed a law in 1956 that acknowledged us as a Native people. But the 1950s was a termination period in which the federal government was trying to end its relationship with Native peoples politically and legally. And so at the insistence of the Bureau of Indian Affairs and certain large tribes, we were told in the bill that we were not eligible for the same services that other tribes received. So we were both recognized and terminated by the same piece of legislation. Only the brightest minds in D.C. can come up with laws like that, right? Just insane. And so that's why we're quasi. Our bill is pending yet again in Congress. Who knows whether it's going to get through. We'll have to see how that plays out. But we are one of 574 federally recognized Native nations. There are a little over 70 state-recognized indigenous peoples. And you heard some of the ones that Carrie mentioned. There are some 100 to 200 non-recognized groups that are pursuing recognition. Some of them are bona fide, some of them are not. The whole recognition process has become muddled, politicized, and there's no extrication from that. We don't want to get into that today, I don't think so. But we are all here, and we're going to be talking about the issue of citizenship. So I identify as belonging to and being a citizen, first of all, of my nation, the Lumbee. That's my core political allegiance. But many Lumbees and most other Native peoples are also proud of having the rights of being state citizens, right? And we also have federal citizenship. As Native peoples, we have 3 layers of citizenship, right? We should be the most protected class of citizens in the country, right? But because of our core indigenous citizenship, the federal government can do things to us that it can't do to others, right? And I'll be getting at a little bit of that in this talk. And so the question of what the citizenship means is very powerful and it's very profound for our people because we really occupy a unique political position vis-a-vis the federal and state government. No other racial or ethnic group members in the U.S. have a similar political status. The peoples of the insular territories do, however, American Samoans, Guamanians, people who live in the U.S. Virgin Islands, and the Commonwealth of Northern Marianas Islands also share some elements that are comparable to our status, but they don't live here, and we have to bear the brunt of federal activities and federal policies that sometimes can be devastating. There are some Native nationalists, many of the Iroquois or Haudenosaunee people, some Hopi, some Seminole, and others who refuse to acknowledge, much less exercise, their rights as American citizens, though the federal government insists that that's what they are. Instead, these Native nationals emphasize that their sole political, legal, and cultural allegiance is to their own nation, their native nation, alone, and not the U.S. or the state that they reside in. As Irving Powless Jr., a Six Nations chief, said in 1994, you, that is the federal government, have passed a law, the 1924 Indian Citizenship Act, that says that we are U.S. citizens. We did not agree to be citizens, and we do not agree that your government could have jurisdiction over us. We do not accept these laws. We are not citizens of the U.S., Powless said. That view is a minority viewpoint among indigenous peoples, but it's an important one for reasons of sovereignty, autonomy, and so on. But that would be a different talk for a different time. Today, I'd like to describe how the citizenship issue arose historically and talk about what it means for Native individuals and their relations with their own nations, the states, and the national government. The Indian Citizenship Act is a hugely important and also a very contested law, and it warrants our close attention, especially now with the new administration that is setting up shop in Washington, D.C. Of course, the national citizenship status of federally recognized Native nations like the Navajo or the Yakima or the Blackfeet is significantly different than the experience of our nations here in North Carolina, who only have state recognition, or in our case, quasi-recognition, with the exception of the Eastern Band of Cherokee. So I'll briefly describe those differences before moving to the ways that the Indian Citizenship Act has impacted Native nations across the country. Unlike most states, North Carolina's original 1778 Constitution allowed Natives and other free men of color the right to vote because we were free, paid taxes, owned property, and or had fought in the Revolutionary War. This no doubt included some Lumbees and other members of state-recognized tribes. But in 1835, North Carolina amended its constitution, disenfranchising all free people of color, including free persons of mixed blood. It did not mention citizens with Native ancestry, however, but since my ancestors were usually classed as free persons of color or mulattoes in the laws and the statutes, our political fate was sealed, and we were thus denied state citizenship rights simply because we were not white. That changed in 1868 when the state again amended its constitution and theoretically restored the right to vote to all those who met the legal requirements and were entitled to vote. 2 years later, the 15th Amendment of the U.S. Constitution was ratified in 1870, and that important amendment says simply that, quote, the right of citizens of the U.S. to vote shall not be denied or abridged by the U.S. or by any state on account of race, color, or previous servitude. Again, in theory, Natives throughout North Carolina were now eligible to vote, and for a time, some did. But as we know, during Reconstruction, Southern states very quickly found ways to deny the voting rights for African Americans and Native peoples. I have yet to see a detailed historical or political study on what exactly transpired during the decades between the end of the Civil War and the implementation of the Indian Civil Rights Act. That would be a good book for some young, enterprising scholar out here in the audience, right? What happened to Natives during that time from 1868 to 1924 here in North Carolina? Were we allowed to vote? If we weren't, why not? What exactly was our political status then? But we know for Lumbees and other tribal citizens, segregation, especially in the wake of the Supreme Court's Plessy versus Ferguson decision in 1896, had devastating consequences for all communities of color in North Carolina and across the country. So let me now turn my attention back to the broader status of Native peoples to see how federal efforts to extend, or some would say impose, U.S. citizenship played out, starting with the major factors that distinguish Native peoples from other racial ethnic groups in the country. First and most obvious is our aboriginality, right? We are the original peoples, the indigenous peoples of this land, right? We are not immigrants, right? So I wonder whether or not Trump's anti-immigration policy, how is that going to impact us, right? He has a record, has a track record of being opposed to Native interests. It's going to be interesting to see how he comes after us. Second, our national status as distinctive polities is affirmed and evidenced through diplomacy and treaty making. No other ethnic group signed treaties with the federal government, and states, as you know, are constitutionally prohibited from negotiating treaties. Since indigenous rights are treaty-based and not constitutionally based, they have only sporadically been protected by the federal government and the federal courts. Clarence Thomas, on the current Supreme Court today, no friend of Native peoples, did write one opinion where he accurately talked about our status. He wrote a concurring opinion in a Supreme Court decision in 2004, U.S. versus Laura, where he said this: the tribes, by contrast to the states, are not part of this constitutional order, and their sovereignty is not guaranteed by it. Right? That tells you where Thomas's head is, right? And his view is now the majority viewpoint on the Supreme Court. So don't look to that body as an organ that's going to provide justice for Native peoples, right? Especially when it comes to treaty rights, sovereignty rights, or conflicts between tribal nations and state governments. Of course, the 6th article of the Constitution declares that, quote, all treaties made or which shall be made under the authority of the U.S. shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. So while Thomas's views Native governments have no guaranteed status or constitutional protection, theoretically the contracts, the treaties that were signed do have a recognized constitutional stature, right, that should provide a solid basis for our sovereignty. And yet, treaties are also political documents, and political documents can be cast out, right? So that's why we're always nervous when Republicans gain power at the federal level, because they have a tendency not to want to abide by the treaty organs because they are merely political documents, even though they have a constitutional stature. I mean, there's something weird about that, right? So there is said to exist a trust relationship also between our nations and the federal government. This means that the U.S. generally acknowledges its legal and moral obligations to support indigenous peoples legally, economically, politically, culturally, right? The federal government, in theory, is the trustee, and Native nations are the beneficiaries of that trust. But the trust doctrine is one of the more nebulous doctrines, and tribal nations can never rest assured that their so-called trustee, the federal government, is really going to act the part. In spite of the federal government's sporadic adherence, the doctrine has still remained a key tenet of government-to-government relations. The Biden administration was a very strong supporter of the trust doctrine. He appointed Deb Haaland, right, the first Native woman to head an agency at the federal level. And he made numerous other appointments. Trump is not going to appoint any natives to his administration, right? I can guarantee you that right now. So that does not bode well for us at the federal level either, all right? The U.S. also wields what has been called plenary power vis-a-vis Native peoples. Plenary, however, has 3 very different meanings: exclusive, preemptive, and unlimited or absolute. And it's the third definition is the one that's most problematic, right? For how can a democratic government, based on the notion of limited government and the rule of law, claim to have the right to exercise largely unlimited power over Native peoples? And yet the federal government has amassed that power, and it gave it to itself in the 1880s. So whenever a tribal nation gets too out of hand or begins to exercise too much power, the federal government can claim and can assert that it has the plenary power to shut that down, right? And it did that in the 1950s when they terminated over 100 tribal nations and said you no longer exist for political or legal purposes, right? So that's an awesome power that the federal government has amassed to itself and holds on to. And we have no way to really challenge that at this point in time. There's one Supreme Court decision in 1978, U.S. versus Wheeler, where the court said that tribal sovereignty, and I'm quoting here, exists only at the sufferance of Congress and is subject to complete defeasance. Fancy words meaning it can be obliterated whenever the federal government chooses to do that. Right? And this is power that's wielded over native citizens who we are told are also citizens of the United States, all right, and the state that they reside in, right? So there's something weird about that doctrine of plenary power when it's defined as unlimited and absolute, right? It contradicts the very meaning of democracy, right, which is limited power, right? And finally, there is the concept of sovereignty. The soul of our people, right? We are sovereign nations because of our preexistence, because of our treaty and relationship to the state and the federal government, and our position in the Constitution's Commerce Clause. We're the only ethnic group mentioned in the Constitution, right? The Commerce Clause says Congress will regulate trade with foreign nations, states, and with the Indian tribes, right? That's the only power the federal government has to deal with us. It's trade, right? But over time, it began to give itself power. And the Supreme Court kept feeding the power to the Congress and to the executive branch. And now we're left with this plenary doctrine notion that is particularly problematic on all sorts of levels, right? But as sovereign nations, we have the power to marry, we have the power to divorce, we have the power to exercise criminal and civil jurisdiction. We have the power to sign treaties with other nations, if not the federal government. We have the power to zone. We have the power to tax. Our sovereignty really elevates us in ways that other racial ethnic groups simply do not have those kind of powers. So with this comparative backdrop, let me now provide you with a quick historical overview of the major events, laws, constitutional clauses, and policies, and let's see how these have affected the status of Native peoples as citizens. When the upstart American colonists decided to rebel against Great Britain, the vast majority of Native peoples saw themselves not as belonging to ethnic groups within a larger society, but rather as distinctive cultural, political, and linguistic nations operating within the boundaries of sacred homelands and beholden to no other nation. Native peoples, of course, were major players in the Revolutionary War and wielded significant political, economic, and military power. An examination of the Declaration of Independence of the United States in 1776 reveals in graphic language the serious concerns that the American founders had about our nations. Thomas Jefferson writes in the Declaration, "He, that is King George, has excited domestic insurrections amongst us and has endeavored to bring on the inhabitants of our frontiers the merciless Indian savages whose known rule of warfare is an undistinguished destruction of all ages, sexes, and conditions." That's pretty powerful language, right? That's in the Declaration of Independence, right? So whenever I'm told I should express awe and reverence for that document, I read this clause to myself and am reminded of what that really entailed, right? How it set the table for what's happened to us since then. And yet, interestingly, 2 years later, the United States pragmatically decided that the best way to deal with Native peoples was to avoid conflict by continuing the formal diplomatic arrangements that most European states had had when they dealt with us through treaty making, right? So the first formal treaty that the United States signed with the tribe was the Delaware Nation in 1778. And that treaty is a short treaty, but it contains an interesting clause, Article 6, which says this: "And it is further agreed on between the contracting parties, should it for the future be found conducive for the mutual interests of both parties, to invite any other tribes who have been friends to the interests of the U.S. to join the present Confederation and to form a state, whereof the Delaware nation shall be the head and have a representation in Congress. So 2 years earlier, we were savages who kill everything. 2 years later, we were being invited to form a native state and join the United States government, right? So what explains that, right? Well, you'd have to come take one of my classes at Richmond. I'll tell you all about it, right? We get into it up there in all this stuff, right? It shows that it's all political, right? It's all political. The Northwest Ordinance of 1787 continued this more positive recognition of the distinctive status of our nations. Article 3 of that important law says, "The utmost good faith shall always be observed toward the Indians. Their lands and property shall never be taken from them without their consent. And in the property, rights, and liberty they shall never be invaded or disturbed, unless in just and lawful wars authorized by Congress. But laws founded on justice and humanity shall from time to time be made for preventing wrongs done them and for preserving peace and friendship with them." See, that's the aspirational the United States speaking there, right? And that law, the Northwest Ordinance, is still on, it's a permanent law of the federal government. So Native peoples frequently try to remind federal lawmakers of this law, right? And say, this is how we are supposed to engage with one another. It's supposed to be based on mutual respect, right? This policy statement has only sometimes been adhered to, however, as the subsequent 2 centuries tells us, right? But it served to clearly affirm the national status of Native peoples. When the U.S. Constitution was adopted in 1789, there were 2 specific references to natives. First, Article 1, Section 2, Clause 3, which dealt with how representatives and direct taxes should be apportioned, used the phrase, "excluding Indians not taxed, 3/5 of all other persons." And this language is repeated in the 14th Amendment. This clause acknowledged that a few natives in the 13 original states had already merged with their local non-Indian neighbors and were now virtually indistinguishable from the general population. For that reason, native assimilation, the Constitution's framers inserted the language concerning Indians not taxed to distinguish Indians already living the civilized life from those who continued to follow their traditional customs and who lived in Indian country, which was, of course, the vast majority of Native peoples, right? But it's the second reference, Article 1, Section 8, Clause 3, the Commerce Clause, which is the most important of the 2 clauses. And that clause, as I said a moment ago, simply says that Congress shall regulate trade with Indian tribes. The federal government was desperate financially and needed to woo Native nations away from other powers who still had designs on America. And it recognized the national status of Native peoples, though precisely what the status meant and how much tribal independence was retained would be something that the courts and the Congress would struggle with for the next several generations. During the course of the next 4 decades, while the federal government was negotiating dozens of treaties with Native nations, a few of which contained provisions that provided Native individuals with citizenship if they abandoned their tribes, it was also passing laws and handing down court decisions in an effort to try and sort out what it wanted its relationship to be with us. While all this was going on, some of the larger eastern Native nations, like the 5 civilized tribes, including the Cherokee over in the mountains, were forced or volunteered, depending on which segment of the tribe we're talking about, to negotiate removal treaties in which they sold their ancestral lands in exchange for lands in what would eventually become Oklahoma. Those tribal leaders and individuals who chose to remain behind were promised, if they so desired it, state citizenship, small reservations of land, and a per capita distribution of benefits that all other Cherokees were entitled to receive under the treaty. The catch was that they could no longer be regarded as Native members, right? The idea of dual citizenship didn't exist back then. But a majority of the 5 civilized nations were removed, and in the process, they secured homelands for their national governments and population with fee simple title And in the case of the Cherokee in 1835, their treaty contains an article, Article 7, which says that the Cherokee Nation, having already made great progress in civilization, and with a view to illustrate the liberal and enlarged policy of the government of the U.S. towards the Indians in their removal beyond the territorial limits of the states, it is stipulated that they shall be entitled to a delegate in the House of Representatives of the U.S. government whenever Congress shall make provision for the same. In other words, where Cherokees were offered a seat, all right? Not unlike that of the Puerto Ricans, who have seats reserved for them in Congress. The Cherokee Nation right now in Oklahoma is pushing the Biden administration in these last 2 months, right, to own up to that provision, right? They've already appointed, the Cherokee Nation have their own Secretary of State, a woman named Kimberly Teehee, and she's ready to serve as a delegate for the Cherokee Nation. But they haven't been able to break through that, all right? Although it's been a little over 150 years, right? So they will continue to try and do that, right? Although Congress as early as 1819 in the Indian Civilization Act had decided that it would attempt to civilize Indian peoples, which sometimes included extending the vote to them, the policy was implemented in an ad hoc fashion. For some reason, a few specific tribes received the brunt of federal attention to make them American citizens. The Stockbridge-Munsee, for example, and the Wyandot were two peoples who from the 1830s to the 1850s faced concerted congressional efforts to make them American citizens. Eventually, the tribes were effectively divided into the Indian Party and the Citizens Party, and they lived under two different sets of regulations. This is evident in the names of some tribes today. For example, the Citizen Band of Potawatomi, right? Or the absentee Shawnee of Oklahoma. But for the most part, Native nations continue to live as distinctive sovereign bodies, continuing to negotiate treaties with the U.S. Tribal citizens' principal political allegiance remained with their own respective nations. The next opportunity to examine Native citizenship in the U.S. arose in 1869 as part of discussions on the interpretation of the recently ratified 14th Amendment to the Constitution. This important amendment said that, quote, all persons born or naturalized in the U.S. and subject to the jurisdiction thereof are citizens of the U.S. and of the state wherein they reside. The Senate's Judiciary Committee was called upon to decide whether or not that clause applied or included Indians, right, under its definition, right, who clearly had been born in the U.S., right? That's where all Indians are born, right, in the U.S. But in an 1870 report written by the Judiciary Committee, it accurately maintained that tribal members were not made citizens by the 14th Amendment because they still adhered to tribal jurisdiction and therefore could not be said to have been born under the complete jurisdiction of the U.S. government. The committee members asserted that such a status required reciprocity, right? That's an important word that a lot of natives use these days, right? That is the consent of Indian peoples themselves before they could be considered American citizens. And this clearly had not been given. And so the committee rightfully said the 14th Amendment does not apply to natives unless those natives have left their reservation and moved into white country, into an urban area, for example, right? And merged into the mass of the people. That's the only way they could acquire U.S. citizenship. There were then a series of contradictory lower federal court rulings in the 1870s that waffled on the status of individual Indians in regards to whether or not they had acquired the rights to vote, especially if they had left the reservation, all right? While each of these cases merit attention, we don't have time to cover those, but I want to mention make a short comment about one important case called Standing Bear versus Crook in 1879, federal district opinion. And while the court said that natives were not citizens in this case, it did say, and it said this for the first time by any federal court, that as individuals we were legal persons under the U.S. Constitution, and we enjoyed the right to file for a writ of habeas corpus. Judge Dundee, who wrote the opinion, words were quite interesting. He quoted the definition of person that you find in Webster's dictionary, which said that a person, quote, was a living soul, a self-conscious being, a moral agent, especially a living human being, a man, woman, or child, an individual of the human race. Dundee then remarked, "This is comprehensive enough, it would seem, to include even an Indian." Well, thank you very much, Judge Dundee, for recognizing that we're human beings. I appreciate that, right? But the first major Supreme Court case addressing Indian Citizenship Act was Elk versus Wilkins. No relation, right? In 1884. In this case, the Supreme Court found that even though Elk had abandoned his tribe, he was a Winnebago, he fled from Winnebago and moved to Omaha, Nebraska, of all places, all right? And he was living a civilized life. He was doing exactly what the Judiciary Committee said Indians needed to do in 1870 if they wanted to become a citizen, all right? And yet, the Supreme Court said he could not become an American citizen and was not an American citizen despite the fact that he had abandoned his nation, because his intent to become a citizen required a positive and specific response from the federal government before he could attain the rights of American citizenship. The court held that natives, like, quote, the children of subjects of any foreign government, end of quote, were not subject to the 14th Amendment's provisions since they belonged to, quote, and this is interesting, alien nations, distinct political communities with whom the U.S. might and habitually did deal as they saw fit either through treaties or legislation. I've always found that language fascinating, that we as natives, original indigenous peoples, are considered aliens under the legal system of the U.S. government, right? Fascinating. Just to note, this is another issue to watch, as the current president-elect has clearly said he plans to limit or even get rid of, at least to some degree, the constitutional right of citizenship itself for peoples that he deems undesirables, right? Who somehow pollute the blood of the people that he deems worthy, right? He is threatening to go so far as to strip existing citizens of their status. For the time being, he seems to have set his sights on those of Hispanic or Latino heritage, or others he views as connected to undesirable countries. But it will be interesting to see if, even as we commemorate a century of natives as U.S. citizens, there is an attempt to declare natives as no longer worthy of belonging, right? It's going to be an interesting ride for the next 4 years, folks. Back to the 1880s. The depiction of natives as aliens directly contradicted what the Judiciary Committee had said in 1870 and left native individuals like John Elk without any recognized national status whatsoever. He was a stateless person, a tribeless person, right? This was an indication of how confused federal policymakers were regarding our nations. While officially federal policy since the 1870s had been moving increasingly towards the forced assimilation of native peoples in defiance of treaties and sovereignty, it was clear that not all national lawmakers were on the same page. The next major effort to address citizenship arrived with the enactment of the General Allotment Act of 1887. This devastating policy provided for the automatic assumption of U.S. citizenship upon receipt of an allotment of land. It sounds good on the surface, but it was a poisonous legal maneuver. While natives did receive the land, it was not exactly theirs, but rather was to be held in trust by their trustee, the federal government, for a 25-year period. Therefore, some courts ruled that citizenship had not been acquired immediately. It would be some time before this was sorted out. For example, in 1905, the Supreme Court handed down a case in the matter of Hef, which held that upon receiving an allotment, a native immediately became an American citizen. And that individual had the right to go off the reservation and buy himself a drink of liquor and just to take it down, right? That was what he was doing at the time he was arrested, right? And he said, I'm a citizen, I've got an allotment. And the Supreme Court agreed with him, right? But that was overturned a few years later. And he said, no, Indians aren't quite ready for full citizenship, right? Because the Christian groups that were interested in saving Native peoples knew that we couldn't handle our liquor, supposedly, and they said we can't allow Indians to drink, no matter whether they're on the reservation, off the reservation, allotted or unallotted, it doesn't matter, right? But Congress also went berserk, as did the Bureau of Indian Affairs and a multitude of Christian organizations, and they amended the General Allotment Act in 1906, which said that even an Indian with an allotment was not a citizen until, again, the end of the 25-year trust period or until the Department of Interior declared the Indian to be competent. Right? So if you were an Indian, you wanted to remain incompetent if you wanted to hold on to your rights, because once you were declared competent, you were on your own. You were subject to having your lands foreclosed, paying taxes, losing your treaty rights, etc. So our status is constantly whiplashed back and forth. But the HEP precedent was eventually overturned in another major Supreme Court case, U.S. versus Nice in 1916. It was anything but nice. This case enshrined in law the fundamentally ambivalent status that Native individuals still have to this day. We are considered both federal citizens and citizens of our own nation. But the ambivalency is this. Justice Van de Vant, who wrote the opinion, problematically mixed the status of Native peoples as nations with the status of individual Indians and declared that, quote, citizenship is not incompatible with tribal existence or continued guardianship, and so may be conferred without completely emancipating the Indians or placing them beyond the reach of congressional regulations adapted for their protection. In other words, we were recognized as American citizens, but we remain subject to the dominant plenary power of the federal government. So is that real citizenship? I don't think so. And yet that is a status that we still have to this very day if you are a member of a federally recognized tribe. Right? Lumbee don't have to worry about that. The Coharie don't have to worry about that. But if and when we ever do gain federal citizenship, we're going to be subject to that same kind of oppression. Right? Plenary power. So by this time, 1916, nearly 2/3 of all natives had acquired federal citizenship, generally through various treaty provisions and through a few congressional statutes, but 1/3 remained solely native citizens. That changed in 1919. Honorably discharged World War I veterans, native veterans, were all given the opportunity to acquire American citizenship. They had to apply for it, right? They had to go through all the rules and rigmarole that you have to go through to acquire U.S. citizenship, and there were a few that did that. 5 years later, in 1924, Congress steps in and unilaterally passes the Indian Citizenship Act, the law that has brought us here today. It problematically authorized the Secretary of Interior to unilaterally issue certificates of citizenship to all remaining non-citizen natives, whether they wanted it or not, whether they had consented to it or not. The act also said that, quote, the granting of such citizenship shall not in any manner impair or otherwise affect the right of any Indian to tribal or other property, end of quote. This clause has been viewed as a recognition that natives have less than complete or only partial citizenship, because in continuing to recognize unique native property rights, such rights are still subject to extraordinary oversight and even confiscation or condemnation by the federal government. In other words, we remain subject to federal plenary power. Okay? A number of natives and tribal governments challenged the federal government's authority to unilaterally impose U.S. citizenship on them, since they were already citizens of their own sovereign nations and had not given their express consent by requesting or applying for U.S. citizenship, which democratic theory and the Judiciary Committee of 1870 had said was an essential requirement. Yet in every case, the government's right to impose its citizenship has been upheld. And tribes have lost every case, native individuals have lost every case where they've challenged the federal government's authority to have imposed that law on them. As of 1924, natives as individuals, but not as nations, were thus considered U.S. citizens entitled to virtually every right and responsibility as any other citizen. Importantly, these rights do not supplant the pre-existing rights of tribal members as outlined in their own constitutions, bylaws, or other organic governing documents. And natives are also recipients of federal services of a distinctive nature that involve holding tracts of allotted lands within the reservation boundaries or selected under federal supervision off the reservation in a federal trust status that precludes most forms of state and federal taxation. Those native nations with treaty relations with the U.S. are also entitled to a unique set of property and other rights, such as a right to hunt, to fish, to harvest rice, to even hunt whales, or in the case of the Makah tribe in Washington state, and to gather medicines on lands in national forests and other territories. But despite being armed with federal citizenship and with nearly 6 decades of forced assimilation policy, those Native individuals who sought to vote in non-Native elections soon discovered that many states, which have the power to establish voting criteria, were not keen on the idea of having Natives vote in their elections, right? They found creative, imaginative, illegal ways to deny Indians the right to vote. While African Americans have continued to face obstacles to voting, such as poll taxes, literacy requirements, gerrymandering, violence, and at-large elections, because of our extra-constitutional political status, we too have faced ongoing battles with similar discriminatory measures being designed to deny or diminish our voting rights. Dan McCool, a political scientist, has written about the subject more than anybody else, and he said that states devise a number of legal strategies to keep Natives from voting. He grouped them into several categories: constitutional ambiguity, political and economic factors, cultural and racial discrimination, guardianship, and residency. States use Native constitutional ambiguity to quash their voting rights. Idaho, New Mexico, and Washington state added clauses to their constitutions declaring that the constitutional phrase "Indians not taxed" was enough to deny Indians the right to vote in their elections. Right? Natives couldn't vote in Arizona until 1948 because of their so-called guardianship status. In Utah, if you were a Native, you couldn't vote until 1956, right? Because you were viewed as a member of an alien nation. I really like that. I like the alien thing, right? And if that wasn't enough, Utah also claimed their reservation residency did not qualify them as state residents. If you lived on a reservation, you actually didn't live in the state, so therefore you couldn't vote, right? Because you weren't a resident of the state. So they had all sorts of laws that they created to deny the franchise to Native individuals who had, by law, been granted federal citizenship. And here in North Carolina, Cherokees, even those with formal education that they had acquired at boarding schools, were denied the right to vote because they allegedly could not persuade the registrar that they could read or write, even though they could, right, in the English language. Lumbees and likely other Eastern Native peoples in the state could vote, but we were denied other rights, such as the right to serve on juries, right? There are other ways that the state disenfranchised us, even if they couldn't outright deny us the right to vote in an election. And for many years, the North Carolina legislature and county governments used a system called double voting that allowed whites who largely lived in towns or cities to vote for their own town's school boards as well as for the county school board members, while voters in the county, most of whom were natives, could only vote for seats on the county school board. In other words, as Melinda Maynard Lowry shows in her research, the white town residents got a double vote, one for their own school board and one for the school board of the local community. The white vote effectively canceled out the native vote, even though that school board made decisions about schools for native children. Natives were thus denied equal representation. Double voting didn't end until 1974 in North Carolina, folks. All right? Disenfranchisement of Native voters is not, however, simply an historical problem. As current research shows, some states, especially in the West, still look for ways to deny or dilute the native vote. A number of books have been written just in the last couple of years that analyze the court cases that natives have filed with the help of the American Civil Liberties Union or the Native American Rights Fund, trying to exercise their rights to vote under the 1965 Voting Rights Act. The situation of natives as tribal citizens is a fascinating and complicated arena and is not easily understood without a deep examination of history, law, politics, geography, and economics. So let me conclude with a bit of discussion about civil rights and Native peoples. When the first hearings were held on the Indian Civil Rights Act in 1961, Senator Frank Church, the chair of the Subcommittee on Indian Affairs, made a broad statement that shocked many of his colleagues in the House. He said this: "We gave the Indian citizenship, true, but for lack of anything else to call it, we gave him full citizenship with one major geographic exception, which was and is now that the Indian tribes are not subject to federal constitutional limitations in the Bill of Rights." What did this mean to the Indian citizen? It meant he had all the constitutional rights of other citizens except that one place, the one place where he lived. In effect, we said, move away from home and you can have the protections of the Constitution too. Senator Keating, taken aback by Church's statement, then asked Church, "So I am sure I understand your line of reasoning here. What you say is that an Indian, if he is on the reservation, is not protected by the U.S. Constitution unless there is also in his tribal constitution or laws a complementary protection there." Church replied, "Yes, and in this case, his protection would derive from the provision in the tribal constitution, and in the absence of such provision, there would be no restriction upon the tribal action that could be taken against him. So the normal universal application of constitutional restrictions that apply everywhere do not apply in Indian reservations." In other words, the U.S. Constitution doesn't apply inside Indian country, on reservation lands. Most Americans don't know that, but it's still a fact to this day. But, and this is where the Indian Civil Rights Act becomes very important, the hearings that were begun in 1961 culminated in 1968 with the passage of the Indian Civil Rights Act. And not many people know this, but I learned this as my wife and I were researching a book that we were doing on Dr. Helen Maynor Shearbeck. She was a young college-educated student in 1961, and she was hired by Senator Sam Ervin, right, in North Carolina. And she is the one who gave the idea for the need for an Indian Civil Rights Act to Senator Ervin, because she had traveled the summer before on reservations out west, and she saw how Native rights were being abused by both their tribal government and the state government. And she said, this isn't right. Natives are having their rights violated by all these different governments, right? That needs to change. And she's the one who introduced the idea that became the Indian Civil Rights Act to Senator Ervin, and that became that important law in 1968. See? So give credit to Helen Maynor Shearbeck for that major law. When the ICRA was adopted in 1968, it imposed, for the first time, statutory versions of most of the U.S. Bill of Rights onto tribal governments, with several key exceptions. As my friend and mentor Vine Deloria once said, the irony of this situation is apparent. The Constitution does not apply to American Indians in their tribal relations. It does not protect Indian tribes. But through a legislative act of Congress, the 1968 Indian Civil Rights Act, some protections, some constitutional provisions are made an applicable part of the relationship between an Indian tribe and its members. As long as this situation exists, confusion and injustice will continue to be visited upon Indian tribes. So the Indian Civil Rights Act imposed certain elements of the first 10 amendments onto tribal governments, but tribes are still subject to federal plenary power, see? So it's still a partial citizenship, in other words. Of equal importance, while all reservation residents, natives and non-natives alike, are now entitled to basic protections from the tribal government's actions, the tribal nations themselves and individual Indians within reservations still are without basic protections from the federal government, which still wields plenary power in almost every sphere of native life: religious freedom, search and seizure, due process, just compensation. I can go on, right? The upshot is the Bill of Rights and several of the later amendments do not apply to tribal nations in their relations with the federal government and have only partial application to Native individuals. So the question must be raised is this: what does American citizenship literally entail for Native individuals both within and without their homelands, a century after the Indian Citizenship Act was adopted in 1924? It is a question that is yet to be definitively answered by the federal government and many state governments as well. It's up to us to chart a new, more collaborative and consensual path forward if justice is ever to be permanently achieved. And yet, as we face the uncertainties of 2025, both the year and the new administration's dark blueprint for governance, the idea of American citizenship is as fraught and fragile as it has been at any time since the passage of the 14th Amendment in the 1860s. I wish I could tell you all that we are secure in our respect for the rule of law and our trust relationship, but I fear that our legacy of belonging means very little to those who now stand to profit from further division and have the means, the plenary power to force their vision of what it means to be a citizen in the U.S. I take comfort, however, in the knowledge that we as Native peoples know who we are, no matter what other status is gifted, imposed, or taken from us. Thank you very much. Gary?
We would like to offer the audience, if anyone has a question for Dr. Wilkins, if you would come up to the microphone, or we can pass it around.
What is the easiest way, excuse me, that we can kind of keep up with what's happening at the different levels, state level, federal level, involving, the worries, especially for the next?
That's an excellent question. Fortunately, my wife keeps me up on social media. I don't do social media per se, but she does. But I know that there are a number of bona fide Native organs that distribute the news that's based on reality and not some conspiracy, right? There are so many conspiracies floating around in the United States anymore, it's hard to find the truth, right? But Indian Country Today is the leading news organ, and that's on the internet. Illuminative is an organization that produces a lot of literature that focuses on Native legal rights. There are a number of national indigenous organizations like the Native American Rights Fund, which focuses on legal problems that Native peoples face. You have the National Indian Education Association. There are a number of organizations that focus on particular issues, and depending on the issue that you're interested in, there's probably a Native organization that deals with that. And I would say go there to begin your search, or go directly to read what Congress is producing, what bills are out there, right? Find what cases have been recently resolved or that are pending before the Supreme Court, right? And read those when they come out, whether they're good or ill for Native people. Read what the court is doing. Don't rely on secondhand information that's floating around on the internet. You're not going to find reality there. But I would focus on what tribes themselves are producing, focus on what bona fide Native organizations and interest groups are producing, and go directly to the source of the law or the policy itself, and read that and make your own informed decision. Yeah.
Any other questions? Yes.
With the conversation now around eliminating the U.S. Department of Ed and what was written in legislation for the Office of Indian Education, what are your thoughts on how that will impact the Office of Indian Education if the U.S. Department of Ed is eliminated?
Yeah. It's going to be devastating, right? Because our charter schools and parochial schools, all this kind of schools, that doesn't do anything for the public needs of all students, right? Regardless of whether they're tribal members or not. And if Trump is able to succeed, and I don't think he's going to be able to succeed in eliminating the Department of Education, there's going to be too much resistance to that. He's going to try mightily, and given the fact that he's put in a woman who is affiliated with the wide world of wrestling or something as a new. I mean, that tells you everything, right there. But it's going to be a real challenge. But I believe that the National Indian Education Association is up for the challenge. Tribal Nation is going to be up for the challenge. And we're going to have to just really hunker down and get ready to fight as hard as we can to keep those institutions afloat, those kind of agencies. But, you know, the fact that Trump believes that he has a mandate now, even though he only got 51% of the vote, right, to do what he's promising to do. And I read that portion of the Project 2025 report that was written about the Department of Interior and their plans to basically gut Indian country of all of our remaining natural resources, right? I mean, that's what they want to do. That's what they intend to do. But again, tribes are more stronger today than we've been in many years. And we are ready to do it. We're ready to do what we need to do to maintain our nations, to maintain our sovereignty, to maintain our treaties and the trust relationship. And we're gonna be able to fend it off, but it's gonna be a real battle. We just have to gird our loins and be prepared to put on the paint, as Vine used to say, because that's what it's going to take. Yeah. Well, thank you all very much. I appreciate you coming out.
Thank you again for being here and for Dr. Wilkins' excellent words today. I know we have probably a few more questions. There's some water and some cookies out in the lobby area, so help yourselves. And I'm sure Dr. Wilkins will be around to have a one-on-one conversation with you if you'd like to stay and ask him other questions. So thank you.